Thank you, Your Honor. I'll be as quick as I can. As I've said in my motion, I previously filed this case in federal court, United States District Court for the Northern District of Texas on March 31st of 2020. That case number is 3:20-CV-759, also Miller versus Dunn et al. That suit involved the same defendants. The federal complaint and the state court petition in this case are virtually identical. I filed suit in federal court because the issues raised are primarily regarding violations of rights under the United States Constitution, and because federal law, 28 United States Code section 1331, guarantees a forum in federal court for such civil actions. I concurrently filed an application to proceed in forma pauperis in that suit. My suit was dismissed, the federal suit was dismissed on September 17th, 2020 under Rooker-Feldman, the Rooker-Feldman doctrine. At that time, my IFP application was also denied. I filed a notice of appeal on October 15th, 2020, and that appeal is now pending in the U.S. Fifth Circuit Court of Appeals in New Orleans, case number 20-1.
Mr. Miller, pardon me for interrupting.
Yes.
I just want to try to get you to slow down just a little bit.
Oh,
I know
sure.
you're trying to move as quickly as possible because of the time constraints, but we want to make sure Ms. Williams can get a record. And so if you could just slow down just a little bit.
I will. I'm sorry about that. That appeal is pending in the Fifth Circuit, case number 20-11054. And my brief of appellant was docketed in that case on March 30th, 2021. And the Fifth Circuit is now considering both my brief of appellant and my IFP application, which I had to file again because initially eventually it was denied in the district court. So I had to refile another IFP application for my appeal. When that case was dismissed from federal court to keep the statute of limitations from tolling further, which has been an issue in this suit, and to protect my rights under the statute of limitations, I then filed this state court civil suit within 30 days of dismissal, and that was on October 15th, 2020. There's a United States Supreme Court precedent that states when the case is filed in federal court, it suspends the statute of limitations for 2 adjacent time periods while the claim is pending in federal court and for 30 days post-dismissal. And that's Artis v. District of Columbia, 138 Supreme Court 594 at 2, and that's from 2018. The statute of limitations, as I'm sure you know, for fraud are 4 years under Texas Civil Practices and Remedies Code 16.004A4, and personal injury and conspiracy are 2 years. My intent in filing the state suit was to serve the suits on all defendants and then request a stay until the federal appeal was complete, and that's what I did. Service took longer than expected in this suit because there are 14 defendants, and one defendant, Ms. Michaelopoulos, died shortly after the suit commenced. The last return of service was filed on April 20th, 2021, so it took that long to get everyone served. And also at the same time, I was working on a petition for writ of certiorari in the United States Supreme Court, case number 20-6965, as well as my federal brief of appellant. So my workload has been extreme lately. I filed this motion to stay as soon as practically possible after the last defendant was served, and that was, I believe, April 21st. There's an issue of jurisdiction that's been raised when there are parallel federal and state court suits pending at the same time, and I'd like to address that. Texas case law indicates that in such a case, in such a circumstance, the first court in which a case is filed takes precedence. Texas Supreme Court case Wyatt v. Shaw Plumbing Company, that's 760 Southwest 2nd, 245 at 248 from 1988. This Texas Supreme Court rule, it is well settled that when suit would be proper in more than one county, the court in which suit is first filed acquires dominant jurisdiction to the exclusion of other courts. And continues, as long as the forum is a proper one, it is the plaintiff's privilege to choose the forum. And then continuing, defendants are simply not at liberty to decline to do battle in the forum chosen by the plaintiff. The same principle applies as in cases of state versus federal jurisdiction. And this is a Texas Civil Appellate Court case, Alpine Gulf Inc. versus Valentino, 563 Southwest 2nd, 358 at 360. And that's from 1978. quoting that ruling. In this case, counsel for appellee filed suit in New York, federal district court, then 5 days later filed suit in Texas seeking the same ultimate relief. Therefore, as a matter of comity, the Texas action should be stayed. And there's also subsequent Texas precedent which concurs with those rulings from 1990, another Texas appellate case from Houston, Space Master International v. Porta Camp with a K, Manufacturing Company, 794 Southwest 2nd, 944 at 946 and 947, quoting that ruling. As a matter of comity, is the custom for the court in which the later action is instituted to stay proceedings therein.
I'm sorry, Mr. Bradley, can you slow down?
Oh, sure, sorry. I'll start at that quote again. As a matter of comity, is the custom for the court in which the later action is instituted to stay proceedings therein until the prior action is determined, or at least for a reasonable time. And the custom has practically grown into a general rule, which strongly urges the duty upon the court in which the subsequent action is instituted to do so. And there's one more case that I'll cite, and it's Miles v. Ford Motor Company et al., 914 Southwest 2nd, 135 at 138. That's a Texas Supreme Court ruling from 1995. Quoting that ruling, this rule is grounded on the principles of comity, convenience, and the need for an orderly procedure in resolving jurisdictional disputes. Certainly, the same principles should therefore apply to an appeal of dismissal of a federal suit while a state court suit is pending. My federal appeal has not been determined, and thus my federal suit has not been determined, and the state court case should be stayed until it is. Allowing the state court case to proceed while my federal appeal is pending would render both my federal suit and my appeal moot, which would be a violation of due process under the 14th Amendment. And also it would violate my right to the forum of my choosing, which was initially federal court. The court should therefore stay this case until the federal Fifth Circuit case is disposed. There are a few issues I'd like to address quickly that were raised in the responses and by more than one party, I believe. And the first one is the fact that there was no service in the federal court case. I requested that the federal court serve my complaint from the clerk, and under 28 U.S. Code section 1915, which stipulates that when a party is indigent, the court shall issue and serve all process. That's a quote from that statute. I asked, when I filed my suit, I asked the Northern District of Texas federal clerk if I should provide service copies of my complaint. And the clerk told me that the court would let me know when copies were required, but I never received any further communication about copies of service from the court. I did not know if the federal district court had served the complaint on the defendants. I could not afford to pay for a service of process myself, so I was at the mercy of the federal court with regard to service. If service has not been perfected, however, federal law does allow the federal district court to extend the time limit for service on showing a good cause. And that's under federal rule of appellate procedure, Rule 4M. Certainly the inability of an indigent litigant to pay for service on his own would qualify as good cause. Another issue is the likelihood of succeeding in my appeal. As I said, my federal suit was dismissed under the Rooker-Feldman doctrine. But it turns out I have related state court appeals pending, more than one actually. The case that's now in the Supreme Court as case number 20-6965, United States Supreme Court, and also 9th District Court of Appeals case number 09-19-00345-CV. And the federal 7th Circuit Court of Appeals has ruled that cases with a pending appeal in state court are exceptions to the Rooker-Feldman doctrine, and I'll quote this ruling. Rooker-Feldman does not apply if a state court appeal is pending, and I'll omit the citations. And also, this is from the same ruling. Rooker-Feldman does not bar claims alleging that the defendants, quote, so far succeeded in corrupting the state judicial process as to obtain a favorable judgment. In my suit, I have repeatedly alleged fraud, well, in this suit as well, and also in my family court case. As you may remember, there's an exhibit attached to the petition in this case that indicates apparently that the defendant Dunn trespassed into my home during my divorce case and photographed legal documents and transmitted them by email to her attorney. Anyway, thus Rooker-Feldman doctrine would not apply to my federal suit for those reasons, and my appeal will likely succeed on those grounds if the federal appellate court applies the law. There wouldn't be any additional delay. In fact, not much anyway. This case has been pending for quite a while now. The brief of appellant has already been filed, as I said, in the federal appeal. I don't know how long it will take the federal appellate court to rule on my IFP application, but it should be forthcoming quickly, and the briefing deadlines will then be set for reply brief. I mean, for a brief of appellee and then potentially a reply brief. It's been alleged that or claimed that my suit is groundless. I am not of that opinion. I think the suit is certainly not groundless. I have extensive grounds for fraud, including fraud, conspiracy, personal injury, and related violations of constitutional rights. And really the grounds, whether the suit is groundless in the opinion of the defendant or defendants, is not relevant because the suit was first filed in federal court, and that federal venue should deliberate these issues. Also, as I said, the Federal Court of Appeals briefing is not complete, which I believe was in Defendant Plumlee's response, or one of her responses. Far from it. As I said, only the brief of appellant has been filed, and there's more briefing to come. There was also an objection to the fact that I had said that I was diligently pursuing this case, and that was in a motion to retain the case on the docket. I diligently pursued the state court case only with regard to service, to keep it from being dismissed and to protect my rights in that regard, but only with the goal of filing this motion to stay. That's pretty much it for my responses, but I'll wait to hear from the defendants and their responses as well. But I would have no qualms about proceeding in state court if it comes to that at all. In fact, I'd be honored to do so, but I think the venue just isn't proper at this time. Thank you, Your Honor.
Judge, we can't hear you.
Your Honor, I cannot hear you. Your Honor, were you saying something? Because I could not hear anything.
Counsel, can you hear?
Yes.
She's the director of IT, the court reporter. She's got to do everything. Thank you, Ms. Williams. Are you still able to hear me now? Oh, fantastic. Then, counsel, you may proceed on me. Well, when Ms. Williams is ready. Now you're muted.
Which counsel, Your Honor?
Oh, I was talking to Ms. Williams. I'm sorry.
I said your video is off, Judge.
It just is doing that on its own. I don't know what's going on. This is okay. Let's try to keep going. Counsel,
Okay.
You may proceed again, Mr. Graydon, on behalf of Defendant Plumlee.
Your Honor, Judge Plumlee presents a big picture and a smaller picture with respect to this motion to stay. The big picture is this is all part of Mr. Miller's pattern of delaying attempts to reach resolution in his lawsuits by a variety of means. He complains in this case of an order from November 17th of 2016 when he attempted to remove the divorce proceeding to federal court. This occurred 30 days after the trial in that matter. But on the day, in fact, 3 minutes before a hearing was scheduled on a motion for entry of judgment, or for an entry of judgment in that post-trial proceeding. That matter was remanded by the federal court the next day because it lacked jurisdiction. And the reason that was articulated that day was that it was a violation of the Rooker-Feldman doctrine. Every time Mr. Miller has sought federal court cases related to this, and there are a number of them, they have all been denied at every level, from the trial court to the US Supreme Court. With respect to his state court proceedings, he has appealed and appealed unsuccessfully at every turn. All of these matters in an attempt to delay and to draw into the net of litigants an ever-expanding group that now includes Judge Plumlee, who presided over the divorce and has continuing exclusive jurisdiction over the family court proceedings related to it. That is the big picture. The small picture here is that Mr. Miller's federal lawsuit has already been dismissed on the same grounds, the Rooker-Feldman doctrine, which I assume that the court is familiar with it, but if you are not, the super nutshell version of it is federal courts do not disturb state court judgments. It is an appropriate thing for the state court to handle, not the federal court. And so when it was dismissed in federal court, because the federal court thought the state courts should handle it, Mr. Miller's confidence that he is going to be successful on his appeal seems misplaced. Even the federal system does not believe he should be in the federal court on this particular matter. With respect to this lawsuit, Judge Plumlee has immunity from suit that she has asserted. I am not going to argue that this morning. That is for another hearing tomorrow. But by asserting it, she has demonstrated that she is entitled to have the court determine its jurisdiction for the claims over her before it considers any of the motions by plaintiff, including this one. And so we would respectfully suggest that the court should not stay all proceedings, including Mr. Miller's requirement that he demonstrate to the court that he has filed a lawsuit for which there is some jurisdiction over clients or defendants, and which is based in law and in fact. These are minimum threshold things that he should be able to do before he filed his lawsuit back in October of 2020. It is now 7 months later, and he is trying to argue to the court that he should not be able to have to demonstrate that because everyone that is listed as a party in this should have to remain on hold while his appeal of a matter where the federal court thinks it should not be in federal court takes place. That lacks any common sense. I do not believe that any of the cases that he cited involved the court staying a state court case based upon a dismissed federal case. And so I would suggest to the court that the court should deny his motion and proceed with the hearings that are already scheduled.
Thank you, counsel. Next, counsel for the estate of Marianne Michalopolis.
Yes, Your Honor. Good morning.
Good morning.
Your Honor, to sort of echo what Mr. Braden just told the court, this whole process is a delay. Mr. Miller is complaining of an order from 2016, emails that were allegedly sent in 2015, communications made in 2015 and 16. And here we are seeing Mr. Miller use this state court as a placeholder so that he can use the forum that he selected in federal court and see how that pans out. And all the defendants are supposed to just hang on the line and see if this federal appeal is the one that goes farther. It should be noted that in the memorandum and opinion order in the federal lawsuit dated November 5th, 2020, the district court certified under 28 USC section 1950A3 that this
I'm sorry, Miss Eric, I didn't hear the site. You were cutting out.
28 USC section 1915A3. The court certified that this appeal is not taken in good faith. And Mr. Miller is trying to tell this court that he has every reason to believe that he is going to be successful in that federal action. And so all the defendants here should just hang on the vine. Mr. Miller filed this action October 15th of 2020, as he said, just to preserve his statute of limitations. He did not issue citation until January 29th, 2021, only because the court had wanted to dismiss the case, motion to retain, and they told him he needed to issue citation and get it served. He did not serve that citation or start serving it until a month later. The defendants are being used as pawns. The state court is being used as a pawn just to preserve Mr. Miller's statute of limitations, which we allege have already passed on actions that occurred years and years ago. I don't believe that Mr. Miller has alleged any valid reason in his motion for stay of proceedings why this action should be stayed any farther than it already has by his own actions.
Thank you, counsel. Defendants Dunn and Finley.
Thank you, Your Honor. Let me give, I'm going to join with what Mr. Graydon and Ms. Eric have already said, give the court a little bit more context. Mr. Miller and Ms. Dunn were divorced in 2014. And the 2016 trial was in a suit to modify parent-child relationship in October of 2016. Judge Plumlee rendered her decision at the conclusion of trial. It was on the record from the bench. The only thing that happened in November was the entry of the written order based on the rendition she had already made. I would also ask that, when Mr. Miller, removed the cases to federal court, they've all been immediately remanded for lack of subject matter jurisdiction. When he tried to appeal both of those remands, the U.S. Court of Appeals in both the Fifth Circuit in both cause number 1611817 and again in 1810897, both dismissed the case for lack of subject matter jurisdiction. Mr. Miller is basically using this process to punish his wife and punish anybody associated with this case who has found anything in Mr. Miller in his ex-wife's favor, and that's really all this is about. Going to the argument with the motion to stay, Mr. Miller said something interesting in his statement. He asked the U.S. federal clerk if he should provide copies. That's an interesting statement, Judge, because he knows that he should have served citation on the defendants, and he chose not to. He's blaming the federal system somehow for his failure to serve process, but yet even he acknowledges that instinctively, all the defendants in the federal lawsuit should have been served with some notice that the federal lawsuit was going on. The only lawsuit that Ms. Dunn and I have been served with, and from what I understand from the other responsive pleadings to this motion to stay, the only lawsuit that's been served, Your Honor, is this lawsuit. And there's no doctrine that Mr. Miller can point to that says that, oh, if I appeal the dismissal of the federal lawsuit, that still stays everything in state court till the federal appeal is resolved. He cites no authority for that proposition. Your Honor, this is just a waste of, quite frankly, everybody's time, including the courts. And the sooner the court hears all the dismissal matters, the better for both the parties and for the court. And so we'd ask the court to deny the motion to stay.
Thank you. Attorney Sherry on behalf of defendant Sherwood.
Yes, Your Honor, we've set forth our position in our paper, but just to touch on an issue that I do not think has been addressed yet, we kind of echo the sentiments of the other defendants. However, one thing that this court should consider is that a granting of this stay will deprive all of the defendants of their rights under Rule 91A dismissal. One of the things that the Texas legislature, when adopting that rule, it was to basically weed out the cases that do not have merit or a basis in law or fact. And in this case, Mr. Miller has simply blown his statute of limitations, at least as to John Shagru. And I know all of the other defendants are of the opinion that that the statute of limitations has been blown as to them as well. That is the sole purpose behind 91A dismissals, is to basically allow the court to dismiss causes of action and lawsuits which on their face fell, and this one fails because of the statute of limitations. And so the only point that I would make that has not been made by counsel yet is that if this court grants the motion to stay, it deprives all of the defendants of their rights under 91A dismissal, because those motions have to be heard and decided 45 days after they are filed. And so that's the only other point that I would make to the court, Your Honor.
All right, thank you. Anything additional that we've not, in terms of arguments that we've not already heard from the Hockaday School?
No, Your Honor. In the interest of time, we echo all of the sentiments of the other parties and just ask the court to deny the motion to stay.
Thank you, Ms. Littman. And on behalf of defendant Diaz and Dallas County?
Your Honor, Judge Diaz is in a similar position as Judge Plumley. I think Mr. Graydon has stated our position fairly well. The claims against Dallas County appear to be either derivative of the claims against Judge Diaz and I guess Judge Plumley, or they appear to be a negligence claim for which we have immunity. In short, Your Honor, both my clients have complete immunity, and we're entitled, as Mr. Graydon stated, under the law relative to pleas to the jurisdiction, to have those determined before any of the merits of the case are determined, and in haste. Granting the stay will not change the defenses that we are going to raise in the plea of the jurisdiction, and will only keep us in a case for which Plaintiff Miller has no hope of succeeding on the merits or succeeding in terms of getting this court to determine that it has jurisdiction over my clients. So for those reasons, we'd ask that the stay be denied.
Thank you, counsel. And finally, on behalf of the city of Dallas.
Thank you, Judge. We would echo all of able counsel's previous arguments. We would also point out Mr. Miller highlights in his briefing in numerous instances his pro se status. That we celebrate the fact that pro ses have access to the court as anybody else does. However, the case law is clear that they are required to follow the same rules of pleading and procedure. Mr. Miller argues in his brief that his pro se status has limited his ability to prosecute concurrent litigation. Under the case law, his pro se status, while there are certain leeways on form and there is no special status accorded to him. Lastly, this just seems to us like taking two dates to the dance and seeing which one you like. And at this point, everyone here has spent countless hours, both public and private dollars, for this to go away. And Your Honor, we would just ask that this court not stay this proceeding. Thank you, Judge.
Thank you. Mr. Miller, again, I do have another proceeding that's in a different setting, so I literally have to switch off from Zoom onto a telephonic bridge. I have about 30 seconds.
Okay, I'll be as quick as I can, Your Honor. I would also like to give you a big picture view of this, and that is that due to the actions of Judge Plumley defendant Plumlee and defendant Diaz, I have not seen or spoken to my daughter in 3 years due to an order that was issued without jurisdiction, which I will show in a future hearing tomorrow. And I've been under a gag order from her court, restricting my right to free speech and my right to parental rights under the 14th Amendment since 2015. It's rather peculiar that both of those things are protected. The free speech is protected under the First Amendment, and Troxel v. Granville and a host of parental rights cases stretching back over the past century guarantee the right to parent without government interference. However, I can't get any appellate court in this country to correct those errors on the part of Judge Plumlee. That's an atrocity, and it shouldn't be occurring in this county. It shouldn't be occurring in this state. And it's unbelievable that I'm not hearing a support of the Constitution from these attorneys who have sworn an oath to uphold the Constitution and laws of the United States and of Texas. It is really revolting. Just quickly, a couple of other points. There's no
Mr. Miller,
delay here.
excuse me, Mr. Miller. Let me see if I can't buy us 2 minutes by at least initiating the teleconference bridge, because I don't want those lawyers to not be able to get on for their hearing.
Thank you, Your Honor.
And then I'll just beg their indulgence for 2 additional minutes so that I can wrap this proceeding up. One moment.
Thank you.
Please.
Thank you.
Mr. Miller.
Yes, Your Honor.
Thank you. Thank you for letting me interrupt. And again, I just didn't want to be distracted knowing that I had to get that initiated. Like I said, I've got about 2 minutes, and then I really do need to give my attention to the other matter. You may conclude your arguments.
Thank you, Your Honor. Just a couple of other points I'd like to touch on. I'm not delaying in any way. There's no family court proceeding that will be delayed by this suit. There's no case in any other court that will be delayed by this suit, by staying this suit. Except for this suit. It would stop the attorneys having to work and bill hours to their clients in this case. If the case was stayed in state court, then there would just be a brief wait while we see if the case proceeds in federal court. And then one way or the other will proceed. And either that court, federal court, or this court will make the decision on the merits of the case. I'd like to address a couple of things. One thing that Mr. Findley said about my removals being remanded, that's true. I removed my case under section 1443 3 times. Twice I went through the appellate system. There is bad law. There is bad interpretation of law. And I think the Georgia v. Rachel decision that basically gutted section 1443 removals is bad law. And the only way to correct it is through appeals. And that's what I've done. I'm not punishing my ex-wife or anything. She's punishing me, as anyone who knows us both, and really anyone who's seen this case and the appeals can tell you. Mr. Finley said there's no authority for issuing a stay of a state court case pending appeal. Well, there's no authority saying that you can't. And the parallel consensus in the Texas Supreme Court and appellate court rulings are that the first court of jurisdiction takes precedence. Mr. Shagru's response about being deprived of Rule 91A rights. Well, if the case was stayed, the clock would stop on the tolling of dismissal countdown. So I don't see that as being an issue. The statute of limitations on several of my complaints is certainly not run. I filed within 4 years of Defendant Plumlee's purported order of November 17, 2016. And fraud has a 4-year statute of limitations. I filed within 2 years of Defendant Diaz's June 7, 2018 purported order, and conspiracy and personal injury have a 2-year statute of limitations. That's not an issue there either, but of course that's for a later hearing. As for the city of Dallas's statement that this is like taking 2 days to the dance, all I can say is I didn't make up the laws that govern statute of limitations, tolling of limitations, appeals, and refiling in state court. If it had proceeded in federal court, that's where we would be. But I'm just following the law as it is, and there's not much I can do about that. And also, if Mr. Ligon thinks that the attorneys here have spent countless hours responding to my suit, I understand that. However, it's nothing compared to the hours that I spent trying to regain access to my daughter, who is now 13, and whom I have not seen in 3 years. That's pretty much it. The rest of it is in my briefs, and I will stand on those as well. Thank you, Your Honor.
Thank you, Mr. Miller. And I certainly am sad to hear of the situation concerning you and your daughter, and the fact that you've not had an opportunity to see her in some time. And certainly, I don't know what circumstances were related to the divorce proceeding, and it's not appropriate for me to comment on that because I'm not the Court of Appeals who gets to review the decisions that are made of that trial judge as they review mine. But what I have to do here is really look at the merits of the request to stay this action. And the cases that you cite, particularly the Alpine versus Valentino case, and I think the other case is the Space National, I think is the other case. But these are interesting cases that are cited because these are cases where it's the other side who's asking to stay the proceeding, of course, not the party who filed the proceeding in state court. And here, this is a bit of an unusual situation because it's not regular for the court to have a person who has initiated the action be the one who's also asking me to stay the action. Nevertheless, that the oddity of that alone did not preclude the court from looking at it more intimately to determine whether it's appropriate to do it. And what you effectively are asking the court to do is to stay this proceeding so that you can allow your federal appeal to play out, hopefully get a favorable outcome, and then proceed in that venue, which is your preferred venue. And the reason that you want to do that is because you'd prefer to be there and don't want to waste time and expense being here when that's the place that you prefer to be. Candidly, I don't see a lot of competition between your interests and the interests of the folks who have responded to your motion. Everyone wants to avoid the needless waste of litigation. They believe that they have meritorious motions that they filed under Rule 91A that would allow the court to dispose of what they consider to be non-meritorious claims. I don't comment or make any judgment on that. I will take each one of those motions and review that record independently and decide those. But as for this first round of things that they are before the court to do, seeking to have the court consider those arguments, it is appropriate for the court to do that. In fact, the court is required to do that within 45 days of their filing. I ask myself, does it disadvantage you in some way for that to happen? Frankly, the sum and substance of many of the motions, if not all of them, that I have reviewed is the kind of thing that you would see in initial round of motions in federal court too. As you know, this is the procedure 91A is fairly new to the state court system, but the motion to dismiss procedure has long been a part of the federal system, and I'm certain that you are familiar with it, having been experienced in that venue. So I don't see that anything different really would happen here than what would happen there in terms of at least getting a court to consider the merits of whether or not the motions ought to be granted and whether or not the case has basis in fact or law. The cases that we use to analyze 91A motions are largely in the federal courts because that procedure has been an available mechanism there for much longer. The policy, as is articulated, I think in most detail in the brief that was filed by the defendant, the estate of Marianne McLaughlin, the policy behind Rule 91A is really served by the court allowing this litigation to go forward. The policy, of course, is for the court to give early consideration to whether or not the case lacks basis in fact or law, so that there can be early dismissal of non-meritorious cases if that's what the court so adjudicates. It would not be served by the court stalling this proceeding, delaying that consideration for another day. And there's not really, as I said, I cannot pinpoint any real prejudice to the court doing that. Finally, I would say that even if the case were to move to discovery for one or more defendants or all of the defendants, depositions that might be taken in this case, there is a procedure in federal court where that testimony could be used in that setting. And so it wouldn't be a waste of resources if in fact you ultimately were successful in your federal appeals and you decided you wanted to non-suit this case in favor of proceeding in that venue. If you got depositions here, they'd be useful in that venue as well if the proceedings were to continue. So those are just some of the reasons. I hope you will find that I try to be transparent in why the court does what it does. It's important to me, whether it's a self-represented person or lawyers who've been practicing many years. It's important to me that people understand why the court does what it does. And in this instance, those are some of the reasons that on the record in front of me, the court thinks it appropriate to deny the motion to stay. Counsel, as I told you, I do need to turn my attention to this other matter. I trust that an order has been uploaded allowing for that ruling, and the court will get an order in before the end of the day. If there is nothing further, you all are excused. Have a great day, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
See you at 1:30.
Yes.
All right.